Good afternoon, everyone, and thanks for joining us for a Tax Practitioners Board webinar. My name's Loon Lak, and I'll be hosting today's session. Today, I'm joining you from Gadigal country. I respectfully acknowledge the traditional owners and custodians of country throughout Australia and their continuing connection to land, waters, and community. I would like to pay my respect to them and their cultures and elders past and present. Today's format is a bit different from our usual webinars. Rather than a presentation, this is an open session where you can ask us questions in relation to your obligations as a registered tax practitioner. To ask a question, simply type your question into the Q&A. To find the Q&A, simply move your mouse over the screen and a range of icons will appear. Feel free to send through as many questions as you like. If you have a question for a specific director, make sure you mention their name to address your question to them. You can also use the chat function to speak with other participants, but if you do need a response from us, be sure to use the Q&A function. I also want to note that we have a lot of people online today, so we may not get to all of your questions. However, we will answer your FAQs via our webinar resource hub. So keep an eye out on our website in the coming week, and we'll share responses to the commonly asked questions there. Today's webinar also counts towards your continuing professional education or CPE, and you can claim 1 hour for attending. In relation to claiming your CPE, we will issue you an attendance certificate to those of you staying online for the webinar today. Now, I would like to introduce you to our speakers. We're joined by our CEO and Secretary, Michael O'Neill, and our directors. They are Christine Gordon, Director of Client Services. We have Craig Woodburn, Chief Technology Officer, Ryan McDonald, Director of Compliance, and Tariq, Director of Policy and Legislation. And we also have Janet Liu, our Assistant Secretary, who oversees policy, governance, and reform, helping us in the chat today. So I'll now hand you over to my colleague, Julia Shaw, who will kick things off.
Thanks so much, Lorne, and good afternoon, everyone. Thank you for joining us today. To get us started, I'd really like to hand over to our CEO, Michael O'Neill, to give us a bit of an update on the TPB plan and some of the focus areas that we've got for the next few months. So, Michael, over to you to get us started. Thank you.
Thank you, Julie, and good afternoon, everyone. Thanks for joining us today. And can I pass on apologies from Jeanette Liu? She's here in spirit, but I've got the privilege of having a bit of a face-to-face chat with you this afternoon. A few things about the TPB and our plans, if I could, just to set a frame for our discussion today. We've refreshed our strategic plan, our longer-term plan, our roadmap, which really says that in order for us to succeed, we have to prepare for reform. We have to look at our own capability around technology, around our people, our culture, and leadership. So like you, looking at the system, the environment, changing expectations, and what are the services required of us to succeed. We call out very particularly the need for effective and trusting partnerships with you and other stakeholders in the system. We need to improve the services that we provide to you and to members of the public. And we need to also address improvements in our regulation practice. All of this is in that context of community expectations. There are increasing expectations of our clients, of the public, of the services that we all provide. And we can do that better by having sessions like this, which develop our shared understanding of that environment, the key risks and opportunities for us to work together. So an example of that is the current consultation program, which allows you and professional associations to provide feedback to government via the Treasury in relation to it changing and improvements to the code. We're committed to continuous improvement. So sessions like this, and always, we welcome your feedback on what we're doing to support you and your clients and what we can do better. And an example of that is that after the government concludes this period of consultation, after it finalizes its determination, the TPB will issue further guidance of a practical nature, which will support you in the work that you're doing on a day-to-day basis. Just a little bit more about reform, if I could. There's been some changes to the TPB, the Tax Agent Services Act, to the tax system, and I wanted to just cover a few of those. Those changes come out of a few different things. Keith James, as you know, did a review of the TPB and said in 2019, the government agreed 2020, these things need to improve in order for the system to work properly. There were some cases that brought some attention to the performance and standards of some practitioners. And in August 2023, the government announced a reform program in order to enhance the regulatory tax system. And so you're aware of those elements that have already been implemented. Disqualified entity rules to ensure that people like you who've got the right ethical experience, educational standards aren't undermined by people who've been disqualified from practice. Changing to an annual registration period, expanding whistleblower protections for those people who want to come forward with transparency to improve the system. Transparency is also improved through our public register data. It's an important part of consumer confidence, being open and transparent with clients. Changes to investigation powers and periods for the TPB, improved information sharing. There's also these code obligations, which I'll talk about in a moment. Those future reforms might include changes to promoter penalty laws, changes to information gathering. The government has also looked at what should the registration framework look like for practitioners. Some of those areas have been subject to public consultation, and there'll be further government announcements about those things. But as to the code determination, a little bit more detail on that. On the 1st of August, the Minister added supplementary items to the Code of Professional Conduct. And those items fall into the broad category of this reinforcing and clarifying the ethical obligations that each of us have as professionals. Those obligations around honesty and integrity, your independence, dealing with government with confidentiality, with competence, managing conflicts of interest. In particular, those powers talk about upholding and promoting the ethical standards of the profession. And many practitioners who are already members of some professional associations already apply that sort of standard through the Australian Professional Ethical Standards, the APES rules. APES 110 to 20 talk about similar concepts. The new code determination addresses false and misleading statements, conflicts, confidentiality. It addresses record-keeping obligations more clearly and practically for tax practitioners. It ensures that services are provided competently, and those areas of competence, reasonable care, are all familiar to us under the existing code. Quality management systems, and about keeping your clients informed about the things that are reasonably necessary for them to make a decision about whether they engage you. The consultation period for these draft amendments to the determination and updated explanation have now been extended until the 2nd of October. And so this gives you an additional opportunity directly or through your associations to provide input and the co-design process. The draft legislation clarifies particularly those matters around false and misleading statements and around advising your clients. And there's a great opportunity for us to continue to ensure that the code and the subsequent guidance the TPB provides make sure that the code is going to work properly for you, for your clients, and for the benefit of the Australian community. Once the code is finalized, then it's up to us as a board to be able to issue some practical guidance. And we'll try to do that as quickly as possible after the government finalizes its law. And again, there'll be a period of consultation so that you'll have the opportunity to be involved not just in settling the law, the determination as it's called, but also in shaping the practical guidance that the TPB will produce after that. And that's important because the government has clarified the commencement dates for the new determination. In relation to most practitioners, the commencement date is 1 July 2025. That's for practitioners with 100 or less employees. And for larger firms, the commencement date is on 1 January 2025. I think that might be all by way of introduction, Julie, and perhaps we pass over to our guests to see what comments or questions they may have.
Perfect. Thank you so much for opening us up today, Michael. And I can see we've got a lot of questions coming through so far. I just want to remind everyone before we do get started, if you have joined us late today and you have a question, if you could pop that into the Q&A, and you'll find that by just hovering over your screen. So just click on that and enter your questions in there. So to get us started, I've got a question for Tariq. This one's from John, and it's in relation to CPE. And John's just saying that for us that work part-time, why can't we receive concessions on our CPE like we do for our professional bodies?
Yeah, thanks, Julie. Good question around CPE. Our CPE policy from the TPB recognises that all registered tax practitioners have to have a base level of understanding and updating of those skills on a yearly and triennium basis. So it doesn't actually distinguish between part-time and full-time staff. It wants to make sure that everyone has a certain level of knowledge and upkeeping of that knowledge, irrespective of whether they're working full-time or part-time.
Thank you for that. Just while I've got you, Tariq, I've got another CPE question, so I might just put that to you at the same time. I've got someone asking, do we need all of our certificates to prove our CPE? And I guess it's a two-parter. The second part is, can we join a software webinar such as MYOB or Xero to get CPE as well?
Yeah, sure. Thanks, Julie. So the first part in terms of the record keeping, we do require tax practitioners to keep a record of their CPE activities. We've developed a CPE log, which you can download from our website. It's a useful tool to record those activities. Alternatively, if you have another form of record keeping, that would be okay as well. In terms of the second question, if you could just repeat that part, Julie.
Yeah, sure. So let me just go back. It says, can we join a software webinar? So
Yes.
something around MYOB or Xero and claim CPE.
Yeah, thanks. So in terms of those sort of CPE activities, if they are relevant to the tax agent services you provide, for example, you're using software programs to provide tax agent services, or you're looking at using software programs for that purpose, then yes, by all means, we do consider that to be relevant, and you can count those towards your CPE.
Great. Thank you so much for clarifying that, Tariq. Michael, I've got a question for you now, and this one is from an anonymous attendee, but they're asking, they have some concerns in relation to R&D tax registered practitioners, and they're just wondering, they're sort of saying that often these people don't have the right tax experience, and they're wondering if the TPB has a position on that.
Yeah, thanks, Julie, and thanks for that question. It's difficult for us to talk about these things in the abstract, but let me perhaps say this, that R&D is one of those important policy parts of the tax law because it includes, it drives innovation in our industry and science and education, and innovation and continuous improvement is really one of the drivers of efficiency and effectiveness for us all, our own well-being. So R&D being such an important policy and a concessional a tax incentive also creates that opportunity for people who might want to abuse that policy. And sadly, we've seen some promoters of schemes in the R&D space, some of whom who are registered tax practitioners, and they may not be promoters fully in the sense of promoter penalty laws, but they might be going to unwary taxpayers and proffering services on, say, a contingency fee basis. They might be proposing that some things which seem to be ordinary work in progress be recharacterized as scientific and innovative projects. And they might be suggesting that these things will give clients a better tax position. I think the majority of practitioners who are doing the honest and ethical thing will spot those people very quickly and be able to advise their clients about the right thing to do. But we also welcome feedback if you're finding that people are undermining your client's position and undermining your position as a real professional, then feel free to talk to us. And we certainly have a compliance focus on those cases because they're very important to us. Thank you, Julie.
Thanks, Michael. Christine, I've got a question for you now, and this one's asking about PI insurance, and it's just saying, how often do I need to update my PI insurance?
Thanks, Julie. As a registered tax practitioner, you've got to provide us with details of your professional indemnity insurance or PI insurance. So all the details of the registered tax practitioner who holds the PI insurance that covers you. You've got to also make sure that the policy with us, whenever you renew your PI insurance details, are provided and are up to date. And the way to do that is via My Profile. And you can enter or visit My Profile from the website. When you log into My Profile, you need to complete a multi-factor authentication process. You simply select PI from the left-hand menu on that page. You'll then be taken to the PI insurance page, and that way you can just update all the information. You can then make any amendments from there. And if you need more guidance, we actually have a video on our YouTube channel, and that helps to update, helps explain how you can update your insurance details. It's really quite simple. Thanks, Julie.
Thanks, Christine. We'll send everyone a link to that video as well. So that'll be in the hyperlinks document we send after the webinar today. Okay, the next question I've got here is from Joel, and this one's around annual registration. So Tariq, I might put this one to you. And Joel's just asking, if my registration expiry is 1/6/2016, is it correct that my first annual registration will be from that date? So is the annual registration as detailed as the previous one? For example, history of lodgements, etc. So hopefully that makes sense, Tariq. So
yeah, thanks, Julie. I think the caller might have meant to say 2026 instead of 2016.
I think so.
Assuming that's the case, yes, your annual registration will kick in from your first subsequent renewal. So if you're not due to renew again till 2026, for example, the annual registration will be for that first renewal from that date.
Great, thank you so much for that. Okay, the next question I've got here is for you, Craig, and this one's just around some of the recent functionality changes that we've made to the TPB register. Could you just give us a bit of an overview around some of those new features, if you can? Thanks.
Certainly, Julie. We've recently redesigned and updated our public register, mostly in response to new government legislation, but we've made some usability improvements at the same time. You'll note it's faster than it ever was, and that the search functionality is being improved too. You can now find practitioners more easily by just typing part of their name, their business name, or their individual names, and there's much more detail now available about registration decisions, and that's an item that the new legislation has enabled. Note, however, that the law only allows us to share the more detailed information for decisions that have been made since early July. So deep past decisions, you may not see all of that extra detail, but you will start to see that fill out from now on.
Great, thank you so much for that. Okay, the next one I've got here, going back to annual registration. So Tariq, back to you. Would you be able to just tell us what the pros and cons are of changing from the 1 year to the 3-year registration?
Yeah, sure, Julie. In terms of, some of the advantages there, the annual registration is a much more streamlined process than what our original process was in terms of the 3-year period. So it does provide a much quicker way for you to register with us every year. It also brings it in line with a lot of other government bodies which seek registration or ongoing registration on a yearly basis. So it's just a opportunity to check in. It does replace our annual declaration process that was there as well. So this is just one process now where you need to register every year, and it aligns, as I said, with the other organisations.
Great, thank you for that. I've got a couple of CPE questions, Tariq, so I might ask you those as well. Darren is asking, is the CPA electronic record keeping for CPE suitable for TPB, and can they share these records with the TPB?
Yeah, thanks, Julie. Provided that the CPA record keeping keeps a record of the relevant requirements that are needed for our purpose as set out in our guidance, that should be sufficient. So if you keep a record for your CPA purposes, you don't need to keep another record for TPB purposes, provided it does meet our minimum requirements. So just have a look on the website of our CPE guidance to make sure that it covers off on necessary information.
Great, thank you. And then the second one we've got here's from Kim, and Kim's asking, can we use CPD from CPA for the CPE purposes of the TPB? So similar sort of question.
Yeah, thanks, Julie. Yes, that's fine, provided the CPE is relevant to tax agent services you provide. You can use that.
Awesome, thank you. Ryan, just wanted to bring you into the conversation as well now, and I've got a question here about unregistered preparers, and just wondering if the TPB has any recent involvement in any cases around unregistered preparers that you can share.
Surely. It's actually quite a topical question. So recently, the Federal Court handed down a decision against a Sydney-based unregistered preparer, Jaden Van Dyke. This was a very welcome decision for us and also a landmark case for us, as the penalty imposed on Mr. Van Dyke was $1.8 million, which to date is the largest pecuniary penalty that the TPB has had imposed against an unregistered preparer. So Mr. Van Dyke was involved in the preparation and the lodgement of income tax returns whilst not registered with us. He was using the MyGov accounts of those taxpayers to lodge their returns, and he was putting at risk their financial information and also their personal information. So it's a really good outcome for the TPB, and I think it demonstrates our commitment to targeting those unregistered preparers. And where we do identify them involved in such egregious conduct, we will take them through the court system, and the court is prepared to issue them with significant penalties for that conduct.
Thanks for sharing that, Ryan. That's a really good outcome. Okay, so Michael, I've got a question here from Shane just about the code determination, and Shane saying that he's confused. You're talking about the government finalising as in it's in the future, but has the determination already been finalised and passed?
Thanks, Shane. It's a good question, and sorry if this is a bit confusing for a lot of us, actually. The determination was enacted on the 1st of August and is subject to this amendment program that the government is opening for negotiation. So there is a determination, but there is an amendment process in play. And so that gives us the opportunity to provide some feedback to government via Treasury at this time until the 2nd of October. And then the government will finalise those amendments. And subject to that finalisation, then the TPB will issue some further guidance, and there'll be another program of consultation. So all of this, as you'd see, Shane, is predicated on how do we ensure there's a co-design process, that people have a say on how this practically impacts you. Thanks, Julie.
Thanks, Michael. I've got a question for you now, Christine, and this one is asking about registration requirements. So someone's asking under what circumstances would they need to have 2 registrations in place?
Yes, that would be when they register as a company or a partnership. They need to have sufficient number of registered individuals who carry out supervisory agents on behalf of the business. So, for example, if they operate their business through a company or partnership, the company or partnership will need to be registered, and you will need to be registered as an individual as well. Or the company will have to have other registered individuals to carry out those supervisory arrangements on their behalf.
Thanks, Christine. Thanks for clearing that up. Ryan, I've got a question here again about unregistered preparers, and just we've got this question asking, will the TPB work with Oz Industry to identify unregistered preparers?
Julie. So the TPB works with a whole host of different agencies to identify the conduct of unregistered preparers, but also to deal with those who are registered but might be providing services that lack competency or otherwise put at risk clients or the integrity of the tax system. So we engage with Oz Industry, with the ATO, with ASIC, with a whole host of different government agencies to ensure that there is that integrity in the system, that trust in tax practitioners to protect clients and protect the broader tax base.
Thanks, Ryan. Might just keep on that similar sort of topic at the moment. So this one's for you, Michael, though, from Jacinta. And she's just saying that our profession's reputation has been damaged by a number of high-profile bad actors. Is there a role for the TPB to share more about what the good actors are doing? And on that note, what is the board's view of how our profession is doing generally?
Yeah, thanks. That's a great question. And I think, can I start with referring to a speech Rob Heffron gave a week or so ago. And he, like the board, recognizes that the majority of tax practitioners are doing the right thing, helping their clients every single day in their engagement with the tax and super system. That's our experience, and I'm sure that's your experience too. Recognizing that most practitioners are doing the right thing, a small number of practitioners doing the wrong thing can have a major disruptive effect on their clients, but also a disruptive effect on the integrity, the reputation of the profession. And if you're complying with the law and I'm consistently not, then that creates this disruptive effect. It breaks the level playing field. And so we don't want tax practitioners to be phoenixing client entities and charging contingency fees, which undermine the good work of the majority of honest practitioners day in and day out. Can I say about the profession, there's been a whole world of change in the last few years. There's a world of COVID disruption to businesses, and practitioners really helped the Australian community, businesses, taxpayers deal with those sort of issues. We've dealt with lots of natural disasters, bushfires and floods. We've dealt with a whole volume of change, and practitioners continue to process change. There are differing client demands, technology demands. In responding to all those changing environmental factors, the majority of tax practitioners are saying, well, what is the requirement? What's the service offering? What's my business process? What do I need to change? And the very best practitioners, if they do identify an issue, they're responding proactively. They're engaging with their clients. Those practitioners who identify serious issues, who engage with us proactively, who come to us and engage with transparency and cooperation, they always get a better outcome for themselves and for their clients. So the TPB will continue to share those messages, and we will continue to address those, as Ryan said, the unregistered practitioners or practitioners involved in high-risk activity that are undermining the credibility of the profession as well as the tax system. Thanks, Julie.
Thank you, Michael. Tariq, I've got a question for you now about confidentiality. And this one's saying the confidentiality requirement refers to third parties, but there's no definition of what a third party is. So they're wondering if an IT person or marketing person of a firm could be a third party, and could they have access to the tax portal and all information on the taxpayer, such as their superannuation and things like that?
Yeah, thanks, Julie. We have published an information product which does give a bit of guidance on the confidentiality obligation, including the definition of third party. But broadly, the third party is anyone other than the practitioner and the client. So if it's the practitioner, it will include the practitioner and their staff and their employees, etc. But if the practitioner engages another party, another tax practitioner or a contractor, it will include those people as third parties.
Thank you. Okay, I've got a question now. I think this one's probably again for you, Tariq, and this one is about CPE again, and this one is what year are CPE hours relevant to?
Yeah, sure, Julie. So the CPE period runs concurrent to your registration period. So the amount of CPE that you're required to do, depending on if you're a registered tax agent or BAS agent, the relevant period is the date that you're registered to the expiry date. Now, you can choose to align your CPE period with your professional association CPE period. So there's consistency in application there. So we allow that flexibility as well.
Great, thank you. Craig, I've got a question here about fraud and identity crime. Just wondering how practitioners can avoid, fraud through identity crime and ensure that the true identity of the person they're speaking to before disclosing any information.
Thanks, Julie, for the question. This issue is rife at the moment. Identity is probably the biggest issue, particularly when we have data breaches with some companies and they're leaking your private information. So it's really important that when someone contacts you or when you're trying to verify someone's identity, that you make every attempt you can to make sure that that's a solid verification. If somebody contacts you, common sense would say that perhaps you should not assume by default that they are who they say they are. You should look up their phone number as an organisation or their contact details and contact them that way. A lot of organisations use authenticated portals or apps, phone apps. That's a really good way to ensure that you're dealing with someone from that organisation. Particularly banks is a big one there. And of course, common sense would prevail. Do your online research, check for slight variations in phone numbers, etc. But just because you receive an email from an email address that you know is a trusted email address, or you receive a phone call from a trusted phone number, don't assume that that they're not faking it. My recommendation would be to just check your facts out and contact them in response.
Good advice. Thank you for that, Craig. I've got a question from Mohammed, and Michael, I think this one's probably best placed with you. And they're saying here that the TPB must promote campaigns about using a registered tax agent on national television and stay away from unregistered preparers. Is there anything that you'd like to comment around that and the work that the TPB is doing in that space?
Yeah, thanks, Mohammed. I think it's useful just to reflect on. I'm sorry. Sorry, I lost video there. So hopefully you can hear me, Mohammed. Just useful to reflect on our role as against, say, the role of individual tax practitioners and professional associations, because our role really supports a triangle of purposes. We're there to support the public. We're there to support those practitioners like you who are doing the right thing. And we're also there to support community confidence in and trust in the integrity of the system. I think most practitioners would say those three goals are part of our reason for existence as well. And professional associations recognize that balance between member obligations and their obligations to the public at large, as all professionals have those broader public obligations. It is the case that every tax time we have a marketing and communications campaign that puts the public on notice that if you're going to use a practitioner, then go to the register, and there you'll be able to identify the person with the right skills, the right locality, the right experience to help you. We also issue cautions about unregistered advisors, like the Van Dyke case that Ryan mentioned before. It's not the tax practitioner's role, the tax practitioner's board role, to be a marketing body. And that's a point of distinction between us and single or particular firms and professional associations. So thanks for that question, Mohammed.
Thanks, Michael. I've got another one for you, Michael, while I've got you there. It's from Teresa, and this one is, do you have any further insights on the political discussion and movement around the new requirement to notify current or prospective clients about matters that could influence the decision to engage a tax agent?
Yeah, thanks, Teresa. I think the questions of politics and policy are not for me as a simple public servant, but I can tell you where the amendments to the determination are landing. And there has been some controversy and some misunderstandings about those, what are described as relevant matters. There's been some suggestion that things like my political beliefs, my sexual orientation, my mental health state are things that I must disclose. And those things are wrong, simply wrong. They're not relevant matters in a client engaging me in the provision of tax services. And government has responded to the need for certainty there by making it absolutely clear what are those things which are relevant. They're set out in a list in section 45 in the determination. And just to give you a feel for those, one of those is that the practitioner will advise clients that the board maintains a register. And that's consistent with our marketing communications program. The register of practitioners provides the community with confidence that you're the right person for them. A practitioner will need to advise their clients how they can make a complaint with us. That's a complaint resolution mechanism. And again, it's a consumer protection tool. And practitioners will need to advise clients if a serious issue impacts their ability to continue operating professionally and ethically. And those things are set out specifically. For example, your registration has been suspended or terminated by the board. If you're involved in bankruptcy, if you're involved in a serious criminal matter, in a tax offence or a fraud matter, an imprisonment of 6 months or more. If you're involved in a promoted penalty matter, sanctioned by the tax office, or if you're subject to a civil penalty by the federal court, where there is a serious civil or criminal matter impacting on a tax practitioner, then those are the factors that need to be set out and disclosed to clients, so that the clients can make an informed decision about about whether to engage a practitioner or whether to continue to engage a practitioner. Thanks, Jodie.
Thank you. I just want to remind people, if you're putting through questions today, we are unable to answer questions that relate to the ATO. So if you're putting those through, we won't be able to respond, unfortunately, to those today. But I do have a question now from Randy, and Tariq, this one's for you. And it's asking, if an employee is working out the BAS but not actually lodging, does that person need to be registered as a BAS agent?
Thanks, Julie. Bit difficult to provide advice on the limited information, but if I can take it that, you've got someone that's working out the BAS but not lodging it. If you're working out figures and advising your client in terms of their obligations and entitlements under a BAS provision and what amounts might be, if that's just advice work, and even if it's not lodgement, that could still constitute a tax agent service. We need to look at the facts a bit more in detail, but as a broad answer, tax agent services are not limited to lodgement activities. They do include advice work as well.
Thanks, Tariq. I guess if you need further clarification on that, you can always reach out to us via our contact us on our website, and we'll be able to give you some more detail on that as well. Okay, the next question I've got here is for you, Ryan, and it's just asking if a person surrenders their TPB registration when an investigation is threatened, will the TPB stop the investigation or will it still be carried through to a solution?
Thanks, Julie. So if a person seeks to surrender their registration just before we commence an investigation, we do have the option of seeking to refuse that surrender. So that's a decision that will be based on the appropriateness of whether or not the surrender should be accepted. And that's a decision that will be made by the Board Conduct Committee and is reviewable by the AAT if the person disagrees with the decision. If we're in an investigation and somebody seeks to surrender their registration, again, whether or not the surrender will be accepted will be based on the circumstances of the investigation, how far through the investigation it is, what is the conduct or the issue that the investigation is looking at and exploring, and sort of what are the public interest aspects as well. Would it be appropriate for the TPB in that circumstance to accept the surrender, or is there a public interest in the investigation being carried through to its conclusion?
Great, thanks for that. Tariq, I've got a question now asking about the introduction of Code Item 15 and 16. So does that apply to all employees of a company tax agent, including those that are not providing tax advice as authorised by the TPB?
So Code Items 15 and 16, Julie, are in relation to disqualified entities, and they do apply in terms of anyone providing tax agent services on behalf of the registered tax practitioner. So that can include employees, contractors, and other similar entities. They don't include administrative staff and people not in the provision of tax agent services.
Great, thank you for that. Ryan, I've got another question for you, and this one is about unregistered tax agents, and it's saying that this person's reported someone to the TPB for being unregistered, and they've also provided evidence of that, and they're just wondering, will the TPB notify or update the person that's made that report as to how the investigation's coming along?
Surely. Sometimes we will contact you seeking further information around what you've reported to us and to assist us further with our inquiries and understanding sort of the risks and what conduct the person is engaging in. But we won't always seek to contact you regarding our compliance work in that respect. We have to balance our privacy and secrecy obligations under the Tax Agent Services Act. So it's hard to say yes or no whether we will contact you and let you know. It will be case specific, unfortunately.
No problems. Thank you for that. Tariq, I've got a question for you now as well. And this one is, are tax practitioners with less than 20 employees required to have a client engagement letter for each individual taxpayer return?
Thanks, Julie. It's a good question around client engagement letters. In our legislative framework, it's not actually a mandated requirement for registered tax practitioners to have client engagement letters. However, it is something that we strongly recommend all tax practitioners to do with their clients. Client engagement letters are a very important tool, and they help to set out the responsibilities of the registered tax practitioner and the client. It can be particularly useful if there ever is a discrepancy. So have a look on our website as well. We've got practice note, and information sheet on client engagement letters and what they could usefully include.
Thank you. I've got a registration requirement question as well, so I might ask you that, Tariq. This one's from Martin, and he's wondering, do you need to be a registered tax agent if you provide depreciation advice to local and/or state governments or other entities that do not pay tax?
Thanks, Julie. Another one that we probably require a closer examination of, but broadly speaking, if you're providing tax agent services and if the depreciation rules fall under Commonwealth tax laws and you're advising in terms of the application of those Commonwealth taxation laws and you'll receive a fee or reward for that service, doesn't matter that it's a government entity or otherwise, it will require registration with the TPP. However, again, we'd require a closer look at the facts and circumstances to provide a more definitive answer.
Thank you. Christine, I've got a question for you now, and this one's asking, when employing a trainee tax or BAS agent, do you need to be registered with, or sorry, do they need to be registered with the TPB?
Okay, so an employee or contractor of a registered tax or BAS agent who does not provide tax services in their own right does not need to be registered. However, if they're working for a registered company or partnership, the company or partnership might want them to be registered as an individual, so then they can get up their sufficient number of registered individual tax practitioners. So registered tax or BAS agents must also ensure that tax agent services are provided on their behalf and are provided competently, which means they must have adequate supervision and control over trainee tax or BAS agents who aren't registered with the TPB.
Thanks, Christine. Craig, sorry, I caught you mid-cough. Just got a question for you about outsourcing. When it comes to outsourcing arrangements, are there any cybersecurity implications that tax practitioners should be considering?
Thanks, Julie. Lucky I had myself on mute. You had me worried there. I was checking. That's a really good question because we actually mentioned it yesterday during our cybersecurity webinar, and now's the time to do a really quick plug. If you look at our YouTube channel, this afternoon, there'll be a recording that pops up for yesterday's cybersecurity chat. It was a really good chat, and we had a lot of questions. It was really great to get into helping some practitioners with their cybersecurity questions. Now, regarding cloud computing, cloud services, and we had a couple of questions here that I've actually answered already just via the system in Zoom, but have a check of those anyway for further reading. But certainly it's worthwhile checking that your cloud provider is reputable, they're security focused. Probably the biggest risk that I can see there is that some cloud providers might be based in other countries. They could be storing your data all over the world. Just be mindful that when somebody transfers your data away from Australian shores, it's no longer protected by Australian privacy law. So, and in some countries, the governments in those countries have every right to every bit of data that resides in that country. So yeah, just be wary of privacy is probably my biggest question, but then security, of course, and any company that's going to store your data, if you ask them those security questions, they should be more than happy to answer your questions, and they want your confidence too. So yeah, just check your cloud provider, ensure they're reputable and they're security focused is my recommendation there.
Wonderful. Thanks, Craig. You're giving me a good segue there to the next question, which is for you, Tariq, and it's about watching previous webinars. So I've got the person here saying, can they still claim CPE when watching webinars that have been recorded? And if so, how do they prove that they've completed that for their CPE log?
Yeah, thanks, Julie. Good question. Our CPE webinars do count towards your CPE, and you can use that for your CPE purposes. Normally, when you attend a webinar, you will receive a certificate from the TPB. I'm not too sure. You might be able to, if you're watching a rerun, just write into the TPB and we might be able to issue you a note to say that you've recorded it. Otherwise, if you just keep a record for your personal CPE records, that will be sufficient as well.
Great, thank you, Tariq. Okay, I've got a question here from Ben. Michael, I think you probably are the best person for this one. And this one's saying, I'm still not clear exactly what, if any, protections we have now when dobbing in, so to speak, former clients for doing the wrong thing, such as reporting to the ATO that someone is not paying their super, for example. Have you got any commentary around that for us, Michael?
Yeah, thanks, Ben. I think if I can talk generally about this, because I'm not here to speak on behalf of the ATO, but all the information that's provided to the TPB or the ATO is treated confidentially. And under the law, you know, Ben, that there are secrecy and privacy provisions which will protect that information from further disclosure. You also know that the whistleblower rules have been extended to provide additional protections to eligible whistleblowers, and that ensures that no adverse action can be taken against people who come forward under those whistleblower provisions. I think it's also relevant, Ben, that part of the determination that talks about false and misleading statements. And just to walk through that those obligations around false and misleading statements, obviously part of our own legal and ethical rules. We just don't do that, right? But there's a recognition that errors can happen. And when I, as a practitioner, am responsible for that error, then the code item 15 simply says I'll take steps to rectify that. Where my client is involved in that process, the new code determination simply walks through a practical process of engaging with the client, some practical steps. And just to set them out in the broad, it will involve me telling the client about the false and misleading statement, about explaining to the client the consequences, the options under the law, the potential application of penalties. It will give the client the reasonable opportunity to explain, a reasonable time frame to address the issue, because good clients and reasonable practitioners will want to be able to address false and misleading statements and set their tax affairs, their super affairs back on an even keel. It also goes to the next step, but what does the practitioner do if they're not confident that the client has addressed the false and misleading statement? And it takes you through those options. And those options are also set out in those Australian Professional Ethical Standards Guidelines 110-220. It says that the reasonable practitioner will consider whether they should withdraw their services. Some practitioners would say, that's the risk management option I have to undertake, because if I continue to provide a service in these circumstances, I could be sued, I could be exposing my professional indemnity insurance, but most important, I'm exposing my professional reputation, my good name. Withdrawing services is one of those steps. Another step is informing the authorities. So it makes it very clear that a disclosure in these circumstances is consistent with your legal and ethical obligations. And another step is that what else you might want to do in the public interest. And those sort of circumstances are again set out in the APES requirements. So the code is intended to provide consistency, with those pre-existing ethical requirements that apply to the majority of tax agents at the moment. Thank you, Julie. Thanks, Ben.
Thanks, Michael. I've got a question from Robert, and Tariq, I'll ask this of you, and it's asking again about the change in registration from 3 years to 1 year. And Robert's just asking, does this disadvantage small tax practices who have less resources for administration purposes?
Yeah, thanks, Julie. Another good question. We at the TPB don't believe that it does disadvantage any tax practitioners. Our view is that the annual registration is a much more simplified process and it replaces the annual declaration. So it's getting rid of a step that practitioners would have been doing. So in that sense, the more simplified registration process, which removes another process, should be seen as a time save for all tax practitioners in the long run.
Great, thank you for that. Christine, I've got a question here about registration and obtaining a receipt for your registration. Just wondering if you could let people know if that's a possibility. They're just saying that there doesn't seem to be an option to claim, to download a receipt once they've put through their registration on the portal. So how do they go about doing that?
At the moment, payments are made to the ATO and they're actually made to the Reserve Bank. So in the online form, tax practitioners go out of the system into the RBA, pay for their registration, and then they come back. And there is a receipt and there is information on the statements. And we are working together with the ATO and the RBA on trying to pull together a receipt that's more integrated into the registration form.
Thank you so much for that, Christine. It's good to hear that it's being streamlined into the future. Thank you. The next question I've got is for Tariq again. So this one's about CPE, and it's just asking what period does CPE start? Is it 3 years from the date of your registration, or can that be based on a financial year as well?
Yeah, thanks, Julie. As a starting point, the CPE period will begin at the time you're registered. However, you can choose, as I've said before, to align it with your recognised professional association CPE, particularly if that runs on a calendar or financial year. So it gives us that flexibility, each practitioner that flexibility to run their CPE period. So they're not doubling up on our requirements and for their professional association.
Great, thank you so much for that. Now, I just realised that we've only got a couple more minutes left in the session today. So I just wanted to note that we haven't addressed all of the questions, obviously. We've had quite a lot coming through. So we will put together some FAQs and we'll place those up on our website shortly. But just before we do finish, Michael, I just wanted to ask you, was there anything that you'd like to close on today? Just anything you wanted to say before we close off?
Thank you, Julie, and thanks to everyone for taking time to engage with us. These conversations really build our understanding, so I hope they're providing some guidance for you. Can I say that the feedback that you provide in the consultation process is designing better law, and it designs for us, helps us to design practical policy guidance. So we're very confident that the strength of the profession will continue to grow, and these reforms are going to be a step forward for all of us. So thank you very much.
Wonderful. Thank you so much, Michael. I'll just give everyone a little bit of information now on how to stay in touch with us. So if you do want to keep up to date, I highly recommend that you visit our website. We have sent you there a few times today, but the web address is tpb.gov.au. You can also follow us on LinkedIn, Facebook, and X, and you'll hear the most up-to-date information there. And also highly recommend that you subscribe to our newsletter, e-news, and we issue that monthly. And again, that has the most up-to-date information that you'll find from the TPB, and you can do that by going to tpb.gov.au/newsroom. And also recommend that you subscribe to our YouTube channel. As we've sort of indicated today, we do record our sessions of our webinars. We place them all up on our YouTube channel. You can view them all there and still claim your CPE for viewing those videos as well. So just wanted to say a big thank you to Michael and to all of the directors who joined us online today. And thank you so much to Jeanette for assisting us in the background there with the chat. It was really helpful. And thank you also to everyone everyone for coming online and sending through your questions. It's been really great to hear, the things that are interesting to you, and this will help us inform our comms going forward as well. So we'll keep all of this stuff in mind, and we'll use that towards some of our updates for e-news and things like that. So we do hope that you have found the webinar beneficial, and it's a great way for you to keep up to date. And as I said, you can claim 1 hour for attending today's session. And if you do want to attend any of our webinars going forward, again, just jump on our website and go to tpb.gov.au/webinars, and you can register for upcoming sessions there. And just finally, before we do finish up today, I'll be launching an exit survey. It's very quick, only takes a moment of your time, and we really would appreciate if you could do that for us. It just helps us in terms of, future topics, and also gives us feedback on how to improve on these sessions and give you the best experience that we can. So the survey just pops up in your browser once you leave the webinar today. And once again, I just want to say thank you to everyone for joining us, and we do hope that you enjoy the rest of your day. Thanks a lot.
Thanks, Julie. Thanks, everyone.